Welcome back to On the Record. I'm Cody Thomas. Hope you had a great holiday. Now, we've been gone for a couple weeks, but we are back and better because while courtrooms may have paused for just a moment, justice didn't stay quiet for long. Now, this week, courts across the country are back open, back in session, and very much so on the record. And today, we're switching things up a little bit. Now, Court TV was everywhere this week, coast to coast, covering some of the most closely watched cases in the country. So instead of zeroing in on just one trial, we're breaking down 3 courtroom moments that changed everything. Moments that stalled cases, shifted strategy, and sparked real courtroom tension. We start in Los Angeles with breaking news in the Nick Reiner case. News that dropped on the very day the case was supposed to move forward. Nick Reiner, accused of murdering his parents, was scheduled for an arraignment, a critical step, his first chance to formally enter a plea. But instead, the courtroom was blindsided because just moments before the hearing, Reiner's high-profile defense attorney, Alan Jackson, asked to withdraw and requested a public defender be appointed.
Your Honor, at this time, I, on behalf of Workman Jackson and Quinn, and with Mr. Reiner's understanding and consent, would ask to withdraw as counsel of record based on the conversation that we've had in chambers and the explanation that we've provided to the court in chambers. We feel that we have no choice at this juncture but to withdraw as counsel and ask to be relieved. The Public Defender's Office has been notified. We've had conversations with them. They are here. They're staffed. They're ready to take over. My understanding is they are ready for the appointment immediately, forthwith.
Good morning, Your Honor. Kimberly Green from the Public Defender's Office. That is correct.
So the court will case, and so that firm is relieved as counsel of record, and the court appoints the Public Defender's Office to represent Mr. Reiner.
That moment stopped the room cold. Alan Jackson, a veteran defense attorney known for high-profile cases, stepping away on the day of arraignment, that's rare. And it immediately raised questions about what was happening behind the scenes. Now, the arraignment was postponed and the public defender stepped in. And just like that, the timeline shifted. Outside the courtroom, Jackson addressed the media.
What we've learned, and you can take this to the bank, is that pursuant to the laws of this state, pursuant to the law in California, Nick Reiner is not guilty of murder. Print that. Print that.
Jackson didn't offer details, but he made one thing clear. Under California law, he believes Nick Reiner is not guilty of murder. That single statement offers a glimpse into what the defense strategy may have been and how dramatically things could now change with new counsel. Zooming out, prosecutors say Reiner fatally stabbed his parents. He faces 2 counts of first-degree murder with special circumstances, charges that could mean life without parole. Now, at this stage, a lawyer change doesn't just slow a case down, it resets the whole board. Now, new attorneys mean new strategy, new evaluations, and potentially new arguments, all before a jury is ever seated. This is a case we'll be watching closely. Now, we're taking a quick break, but when we come back, we head to Georgia, where a high-profile teen murder trial didn't move forward at all and instead was pushed months down the road. In Georgia, the trial of Sarah Grace Patrick, accused of killing her mother and stepfather, was set to begin with jury selection. Instead, the judge hit pause.
Based on what's been presented for me today, I will place this on, I believe it's August 3rd. We'll place this on August 3rd. And with the understanding that if I'm going to bypass 2 trial weeks in order to get there, I'm bypassing 2 days that I can set it on. Right? But by doing that, I'm giving defense and state all the time that you could possibly need to have this case ready. And August 3rd needs to be our day. We need to come in August 3rd, ready to pick a jury. All right? Where everyone's on the same page.
Yes, sir.
The trial was delayed until August 2026. Patrick was a teenager at the time of the alleged killings and faces 2 counts of murder and 2 counts of aggravated assault. Prosecutors say she shot her parents, then allowed her 5-year-old sister to discover the bodies before calling 911. So why the delay? A neuropsychological evaluation, a deep dive into Patrick's mental state and competency. The preliminary report didn't arrive until the end of December, leaving both sides needing time to review and prepare. Now, in cases involving juveniles charged as adults, evaluations like this can shape everything from guilt to sentencing. What makes this case even more complicated? Support for Sarah Grace doesn't stop outside the courtroom. It's coming from inside her own family, including her maternal grandfather.
There was nothing, DJ, her father, he's a good person, and he and Kristen got along very well. They had their disagreements, but they had been divorced for so long that they got along quite well, and they were cooperative, and Sarah would go visit him at times. The statement was made that Sarah was sort of like a nomad, that she lived in different places. Well, that's not true. I mean, she lived with Kristen, my daughter, from as long as I can remember, as long as they owned that house, which was quite a few years. And, she would go stay with her father once in a while, but the only time I know that she moved anywhere was after this murder, and she needed a place to live. They had their disagreements, just like any teenage daughter would have with a mother. But Sarah was a good kid. I mean, she really was.
Another quick break, and then we head to Texas for the most emotionally charged courtroom moment of the week. In Corpus Christi, Texas, a case tied to one of the deadliest school shootings in U.S. history took a dramatic turn. Former Uvalde school police officer Adrian Gonzalez is on trial, not accused of pulling the trigger, but of failing to act. He faces 29 counts of child endangerment stemming from his response during the Robb Elementary shooting. Now, this week, one witness nearly derailed the entire case.
Do you agree that seeing a man with a gun on your campus is an important detail that you would recognize instantly that you would need to talk about?
I mean, I know that now, yes.
Well, and you would have known that then?
Possibly.
Because I think what you were saying when he was talking was that you didn't think that what the information you were providing was, in the scheme of things, I guess very important. I didn't hear you because you were talking.
Yes, I didn't think that what I had to say was very important. I didn't think that it mattered based on or compared to everything else.
I understand, but seeing a shooter and being shot at are important details. You would agree with that?
I mean, it depends on who you are. I don't know, I guess. Possibly.
I'll pass.
Just one more question, Your Honor. Of the three things, Mr. Goss has agreed that you did tell the grand jury it was provided to them that they saw clouds of dust on the playground, correct?
Yes.
But he said that you did not, or the information was not provided, and you did not say before that you saw the person on the south side of the building. Is that correct?
Correct. Oh.
But you were asked that question from the grand jury, weren't you?
I just read that. Yes, sorry.
And would you tell us what you told the grand jury?
Yes, it was towards, obviously, the building indicating. So I'm guessing I was pointing at that time or something. At that point, the coach had yelled, "Hey, get in the room."
No further than that. I'll just the whole point. So the specific question was asked where, and you said obviously toward the building, and then it says indicated, so you pointed to something. Is that correct?
Yes.
So that information was provided to the grand jury.
Yes, sorry.
And the defense.
Yes.
Absolutely.
Okay, Judge. All right. I'm sorry. I don't want to do this to you. I'm sorry he keeps doing it. Saw this person on south side of building, and I'm not irritated with you. It's them. Saw this person on south side of building. Now, what you just read from the grand jury, you agree with me. You never told the grand jury that you saw the person on the south side of the building, however he's trying to make it seem. You would agree with that?
Yes.
Shots coming from a location is not, I saw this person on the south side of the building. You would agree with that as well?
Yes, but wouldn't it be, I don't know, it's kind of implied?
You're saying that it's kind of implied, but this phrase right here, I saw a shooter and he was on the south side of the building, that was never said to the grand jury or at any other time, except in December when he told the prosecutors and they didn't tell us.
Yeah.
Pass the witness.
No further questions.
The defense was blindsided. A teacher's testimony changed their understanding of the scene, and the defense immediately moved for a mistrial, which the judge ultimately denied. He did, however, end up striking Stephanie Hale's testimony from the record entirely, instructing jurors not to consider it at all.
I don't want you to speculate about the reason for this, but I will tell you the law mandates that I do this, and I don't want you to wonder why or the need for it, but we need to follow the law, and I'm going to direct you in that regard, and I'm going to expect you to follow it. So listen carefully to this instruction, if you would, ladies and gentlemen. We have just heard testimony, as you know, from the witness Stephanie Hale. The court, outside your presence, after a hearing mandated by law, has ruled that the witness's testimony will be and must be excluded as a matter of law. Therefore, you are instructed to disregard any and all testimony provided by Stephanie Hale, and her testimony will play no role in your analysis, deliberations, and decision in this case. With this instruction, you are reminded that you are bound by your oath as a juror to follow the ruling of the court as provided. So please remember, ladies and gentlemen, mandated by law, don't speculate about it, don't wonder about it, don't hold it against either side, just follow my instruction.
The ruling kept the trial alive and preserved the defendant's right to a fair trial, but then the judge did something, again, unexpected, but respectable. He called the witness to the bench, personally explaining the ruling and thanking her for her bravery. A powerful reminder of how fragile and emotional cases like this can be.
Ma'am, could you come up to the bench here very quickly? We're going to let you go here in a minute. I hate to talk to people from the bench. You don't have to sit down, just right here. I just want to tell you, you may hear later on that I will instruct the jury to disregard your testimony, but I want to emphasize to you, you did absolutely nothing wrong. It is not on you. And I want to tell you just from personal experience, memories of traumatic events change, are different, or you recall more or less. I had a personal experience many years ago. My wife and I were hit by a drunk driver, and I spent 2 months in the hospital. Apparently they almost lost me in the emergency room, but revived me. And I remember that event very clearly, that truck coming at us and trying to get out of the way. But every time I think about it, it's a little different. And that's because of stress and trauma. So nothing about this is on you. We appreciate your bravery that day, and we appreciate your testimony and being brave enough to come in here, and you are excused with our thanks. Take care.
This trial is about accountability, about duty, and about decisions made and not made when seconds matter. Few cases test law enforcement responsibility like this one, and as it continues, every ruling carries enormous weight. Stay with Court TV as we follow this case, gavel to gavel. 3 courtrooms, 3 moments, 3 cases that remind us just how unpredictable and powerful the justice system can be. That's why we stay on the record. I'm Cody Thomas. Thanks for listening. Stay safe, stay informed, and join me next time we do go back on the record.